explain what are the different types of bail or circumstances of release that someone who is being arraigned can be set upon, like it can be set on them.
Yeah, and I'll explain just briefly, because you're right that it was available prior to 2020 and judges didn't do it. So that was actually one of the lesser kind of known parts of bail reform, was that it mandated that judges now have to set bail in at least 3 forms. Yeah. And one of those has to be either a partially secured bond or an unsecured bond. Judges don't like unsecured bonds, so that means that in most cases
I've never seen that.
Yeah, in most cases they're now setting partially secured bonds to meet that requirement. But yeah, just a brief sort of overview of the different types. So cash bail is like, I think, what most people think of when they think of bail. It's, a set amount and you have to pay that full amount to the court, and that sort of is the trigger for your release. So if it's $10,000 cash bail, you have to go to court with $10,000. Yeah, and then the other types of monetary release mechanisms are things called bonds. So there's generally a few types of bonds. Partially secured bond, which is the one that Bryant mentioned, is it was supposed to be a way for folks who didn't have large sums of money to still be able to post for their client. The idea was that instead of having to put the full amount down, you only have to put a deposit, which is capped at 10%. So it can't be more than 10% of the full amount. It can be less, but we see that judges always err towards the very top of the threshold. So most partially secured bonds are set at 10%. And so that means if the partially secured bond amount is $100,000, you would only have to come up with $10,000 as a deposit. And the way it works is you go and you pay that deposit, and you're basically promising that if the person you're posting for doesn't return to court, then you're acknowledging that you're on the hook for the rest of the $90,000. So
and in practice, that becomes the hard part, right? The ability to show that you can be on the hook for the other.
So basically, I'm transparent with our clients, and I let them know the pros and cons. Like, you could be eligible, you could be liable for this amount of money if the client doesn't show up, and and they make the decision right there.
Yeah, I obviously to get someone to agree. I mean, in the sense of getting proof of income, right? Because I know in Queens, basically you have to provide basically the equivalent of double.
Yeah,
you can probably get a little less. But most judges err on if you want to safely go in there, you have to show proof that you can pay the other part to the point of double the amount of what the bail is.
And mainly, I've had a lot of success in collecting those documents, helping the client navigate that process, and I say majority of our clients' families they do come up with the necessary documents to prove their income. Their W-2 income, yes.
And what's the necessary documents for the partially secured?
So all it requires is just a W-2 income. That's in the Queens, they require double the amount of the bond. So if they have a necessary income, documents like W-2,
pay stub. I typically, whenever I have a client who is on bail and I'm talking to their family, I typically say, if you want to be safe, 2 to 3 months of pay stubs, and at least 1 to 2 years of W-2s. So typically that will get past the hurdle.
Yeah, and I'll say all of these things that we're talking about, these are not statutory mandates. These are things that judges have decided to do and as a means of weeding out folks. So the purpose of partially secured bond is supposed to be so that it's easier for folks to pay, and judges have come up with these arbitrary rules about, I want to see a salary of twice the bond amount, or I want to see X number of years of tax returns, and I want to see this, and I want to see that, as a means of making it not accessible to our clients' families in order to be able to pay. So it's a really perverse interpretation of the statute for judges to be requiring these sort of excessive documentations and excessive salaries. If somebody, because they routinely set partially secured bond higher than cash bail, so
that's the most nefarious part.
Yeah,
because before, prior to 2020, you would have let's say it's a gun case, $20,000 bail, right? You would get a bond. The bond would set the same thing. So
Yeah.
now you have the ability. So bond is one of the other ways to pay bail. And the problem with bond is that you have to go to a bondsman.
Insurance company bond. Yeah.
Insurance company bondsman. Yeah, you go to a bondsman. You have to put 10% down, which they're gonna give to the court, and then which you're not gonna get back. And then you have to put collateral. The collateral you will get back, and they determine how much collateral based on, I guess, your credit worthiness or the assets you have. And then you lose that 10%. And in practice, what they would do is, you would imagine if pre-2020 it would be cash, bond, and then you're adding one, so partially secured, it should just be the same amount.
Yeah.
Which would allow that if cash is 20, bond is 20, then the partially secured surety bond should be 20. And what they will do instead is, all right, I mean, the most nefarious thing they can do is say 20, 20, 200.
Yeah.
Which is fucking insane. Because
Yeah.
then it's like, partially secured surety bond is, I got to give you $20,000 and agree to.
And you
Yeah.
got to
on the
show.
hook for
And you
200
got
is
to
insane.
show. They might want 400,000.
Yeah, which is insane. I mean, most judges won't be that bad, but they will definitely make it where the partially secured surety bond, instead of being 10% of what cash is, it's more like 30% or 40%, even 50%. But
So we don't like to use the insurance company bonds, but sometimes like that's the last alternative where the client is forced to do that because, like you said, they don't take the whole 10%, but they take a fee. Because there's legally what they can take. We got like
there's a maximum cap on
so they got to give a certain amount back
as a fee, but you don't get all your money back in the way that you do with partially secured bond. Like they're allowed to keep some of it.
I thought it was
Yeah.
all.
Yeah.
I don't know. It was all 10%.
Yeah, so
It's a substantial amount.
but it's very like invasive. Like they'll ask for your financial information, your spouse's, her social security, all these things. Because they want to like tie as many people to that debt, you know what I'm saying? So it's like, I don't really like it. I don't like it. And even though to me, from partially secured bond, I mean, it works in some instances, but at the same time, I think it just changed who profits from it. Because I still think that the state is because now we don't see a lot, but I do see some instances where the client doesn't show up and the family's on the hook. And, it's the court that's demanding the money. I mean, there's ways to get it remitted. You just file a motion or whatever.
So what is the process if someone doesn't show up? Because I've never been on that side of
the
it.
court will send you, they'll send the family, the person that's the obligor, they'll send them a court document saying you owe us this amount of money. They got to respond in a certain amount of time. So there's a remission. There's part of bail. I think it's in the bail statute. It's about remission of the bail if you owe it, if it's forfeited. So you basically, if you show that like the court didn't go through any further expense in the client returning, like for instance, if you especially if you like navigated, like you reach out to your family member and you said, listen, turn yourself in or whatever the case may be. But as long as it wasn't like a process where it cost a lot of money, so there's a way to get it.
So they measure how much. It's interesting because it's like, these cops got to work regardless. So did you spend that money to get this guy to come back?
We talk about like if somebody's
like they
manhunt.
They go out of state.
Yeah, and they something extreme.
Okay.
And most people who miss court, like they're not, and I think this is the thing about the bail statute, that it's very clear. So first of all, most people don't miss court. I think 90+ % of people return for all their court dates.
Right.
But the statute is very clear that the purpose of bail is to avoid flight from prosecution. And even people who occasionally miss court date, because, lots of folks who are going through the criminal legal system are unstable. They don't have phones. They're unhoused. They may be struggling with substance use disorder. Mental illness. And so they're not fleeing prosecution. If, you go out on the street, you could probably find them out there. It's just, they're not.
They suffer from something.
They're not able to keep track of their court dates.
I think there's a myth that like every person, I feel like it's a myth that every person who doesn't show up to court somehow has the mechanisms to free this prosecution, in the sense of like they got enough money to leave the state.
Yeah.
Like, I don't got enough money to leave
Yeah.
New York. My license is in New York City.
Yeah.
I'll be a bum in Philly. Like,
Yeah.
like,
Yeah.
I don't got no money to be anywhere but here. I can't imagine my average client. Now, obviously, in theory, if you have family somewhere else, but then even then, what life are you gonna have? You can't use your fucking social security number.
Yeah.
Like, it's like it's
murder.
maybe if you charge with murder,
But still,
it's like.
And the data, that's actually a really
not
interesting
sustainable.
point because the data has consistently shown both nationally and locally in New York that the people charged with the most serious offenses are actually the ones that are most likely to return. It's folks who are charged with like the low-level misdemeanors and things that, you know, end up missing court. But like folks charged with most serious crimes, like they are consistently the cohort that comes to court, you know, most often. And it's like an inverse relationship with judges. Like they always want to set bail higher on people charged with the more serious offenses, even though those are the folks that are the most likely to not miss a court date.
Now, go ahead.
So you mentioned a few different types of bail, but are there others? I mean, we got partially secured, unsecured, insurance company bond, and cash.
They have non-monetary conditions too, like ROR. They have supervised release. A lot of clients they work with supervised release, so they get like supervised release. Make sure that they know when their court dates are. Give them type of resources, programming, and stuff like that. So like that's ran by CJA, right? Criminal Justice Agency, right?
Criminal Justice.
So yes.
Is the CJA everywhere?
In New York City, yeah.
I think different boroughs have different providers
For the supervised release
for the
program.
supervised release
Okay.
program. Yeah, I think different boroughs contract with different folks.
But CJA is in Queens.
Yeah, I think CJA is Queens. I think BJI, Brooklyn Justice Initiative, is Brooklyn. I think cases might be
Cases in
Manhattan.
Manhattan,
Yeah.
Okay.
But yeah, so like, there's those types of bonds. There's obviously, I don't think I explained the unsecured bond, but the unsecured bond is where you don't have to put any deposit down. You're just
You gotta
throwing it.
promise.
You just got to promise that you're going to pay the full
You never
amount.
get- you're not sure.
I've
Judges
never seen that
rarely
happen.
do that. I think I've heard of it happening in one case maybe. But obviously that's the most accessible because it doesn't require the family to have cash on hand right now to be able to post. And then, the non-monetary conditions that Bryant mentioned, whether it's supervised release, whether it's electronic monitoring, which is run through the sheriff's office. That's where you have to get the bracelet and like GPS track you.
Is that even available now, the electronic monitoring?
Yes.
Yeah.
Yes.
Yeah. What is the logistics? 'Cause I've got it done once, but that guy was out, and the judge was really mad. It was like, I don't know why you out, but I'm putting ankle monitor on you. So logistically, it was easy for him to go get it. But if you're in, like, what is the turnaround time on getting the ankle monitor?
It varies.
Yeah,
It varies?
it depends on like how understaffed the sheriff's office is at any given time. So sometimes they can do it really quickly and they have to actually go to Rikers to put it on. So like sometimes they're able to do that within a few days. Other times it takes weeks.
So people are placed into Rikers until the ankle monitor gets put on them, even though they're
Some of them are already
released?
detained. They're already detained.
But if I can say, he's saying if they get arraigned and the order is ankle monitor, it will take days to get it on them.
Because the sheriff have to check the person's where they're gonna live. They have to get this paperwork from the court, and then they do all their assessment to see if if this person's eligible for it. And then once they do that, they send the paperwork back to the court, and then the court judge signs off on it, and then.
Does it cost a
No,
defendant?
it doesn't cost.
It doesn't cost any money, no. And then, so judges have the authority for like someone who, let's say they want to release the person, like let's say bail was set and then they decided to reduce it to electronic monitoring. They have the authority to release the person and let them self-report to the sheriff's office, which I think is somewhere out in Queens.
Yeah.
And then have the monitor put on there. So that's something that we frequently ask judges to do. Some judges will, let our clients just go to the sheriff's office themselves and get it placed on.
Yeah.
But other times they say no. And in those situations, if the person is, was previously at Rikers, then they have to wait until the sheriff can come to Rikers to put the monitor on.
Arielle, explain to them how, after a certain period of time, that like EM is like it's similar to being incarcerated. So that's like our last alternative too. But tell them how the time period takes for like you can modify that securing order.
Yeah, so the statute actually has it, and a lot of folks don't do this. So I hope that if there are any lawyers listening, you guys take notes. The statute says that the court has to consider lessening the restrictions. If they put somebody on electronic monitoring, and let's say they say, I'm putting you on electronic monitoring with house arrest. They have to revisit that determination within, I think the statute says 60 days. It's either 60 days or 90 days. I'm blanking on which one, but it's in CPL 51040 subdivision 3. And basically they have to lessen the restrictions if the person has been doing well on electronic monitoring and they, haven't gotten any violations and they've been doing what they're supposed to do. A lot of judges don't know that, and a lot of attorneys don't know that, so they don't ask for it.
Is it that they have to, or that they can?
They have to, must. It says must.
They have to consider. They have to consider it. They have to hear you, and they have to. If they're not going to do it, they have to justify why. So if somebody has been, doing everything they're supposed to be doing and complying with all that, it would be really hard for them to justify why they're going to keep them on house arrest. Yeah.
I handle cases federally.
Yeah.
And federally, pretty much everybody gets an ankle monitor.
Really?
Oh, really?
Pretty much everybody.
Really?
You're either in jail or you're on an ankle monitor at home.
Yeah.
That's pretty much everybody in federal court. So the thing about it is, if you say to a judge, he's doing everything he's supposed to do on release, and I want you to consider lessening the conditions, the response is going to be, he's doing everything he's supposed to do on release because that's what he's supposed to do. That's not a reason to change his conditions.
Yeah, I mean, I can see judges say that, he's only doing what he's supposed to do because I have him on house arrest. But, I mean, the legislature, when they crafted that statute and put that provision in there, very clearly and explicitly, was signaling to judges that you should be lessening people's restrictions if they are doing what they're supposed to do, because the way the statute is set up is that judges are supposed to set the least restrictive means. So they changed the language a little bit. It no longer says least restrictive after the 2023 rollbacks. Now it says the kind and degree of control or restriction necessary, which means the same thing. As shorthand, I'm just going to keep saying least restrictive because it's just less words.
They obfuscated the language to make it more palatable.
But the whole point is that judges are only supposed to set those conditions which are absolutely necessary to get somebody to return to court, and the lessening of restrictions is supposed to be part of the process if somebody is doing what they're supposed to do, and they're showing themselves to be trustworthy and reliable, that suggests that they can do with some lesser restrictions. And so that's sort of the framework of the statute and the way it's supposed to work, that the legislature crafted it in 2020 for that purpose, to try to hopefully get less people entangled up in Rikers, but also in these more restrictive types of non-monetary conditions like having to wear an ankle monitor.